Alternative dispute resolution, mediation process. There are many advantages compared to a few disadvantages of mediating a dispute. Due to the numerous benefits, a mediation process is most likely to be successful because it allows all the parties involved to be in control of the conflict. Undoubtedly, this is a better mechanism of dispute resolution as both parties can settle their disputes amicably without any external control. In addition, the mediation process is private, and for this reason, the public respect for both the disputants will probably be upheld when they sort out their differences. A notable feature of mediation, among other things, is that the costs involved are minimal compared to the expenses of dispute resolution taken through litigation. As evident, a mediation process is one of the best alternative dispute resolution strategies that easily succeed. Despite the advantages that disputants can derive from the mediation process, there are also some flaws attached to it. With privacy that is linked to the nature of mediation, the procedure does not guarantee the prevention of the same misconduct by an offender. This is specifically true when the defendant's conduct was intentional. Again, in mediation, parties that are not at the same level of social hierarchy discuss their issues together, and therefore, it is open to manipulation by the party who is deemed to be superior. More explicitly, if the aggrieved side happens to be inferior to the offender, certainly, the former may not receive the compensation as per his expectations when compared to the judicial process. In the end, the relationship between the offender and the aggrieved party is strained, and therefore the parties remain hostile towards one another. From the nature of mediation, it is always an unstructured discussion between parties to reach an agreement before an impartial mediator. This means that the physical presence of all the parties is not always an obligatory condition. In a case where either party feels that they cannot attend the conciliation proceedings in person, they can be represented by attorneys, or do a video call. When the client is represented by a lawyer, the main roles of the attorney-advocate are limited to advising them on the procedure and substantive law, counseling, and managing the legal process for their side. During mediation, the lawyer continues to advise the client the same way as before the process, helping to understand what information will be important to share or to learn. In essence, an attorney-advocate acts in the best interest of the party they represent in ensuring that their side bears full responsibility for solving the dispute. However, there are issues of conflict of interest concerning a lawyer's representation that any party who has opted to be represented by an attorney-advocate needs to recognize. It means that the client should be aware of how the lawyer's actions on their behalf are likely to affect the mediation process and consequently the outcomes. For instance, the client should be aware of any past legal involvement of the hired advocate with the other disputant. Also, the party being represented by the legal practitioner should ensure that there is no blood relation between the other party and the hired lawyer. In simple terms, a declaration of no conflict of interests by the attorney-advocate acts in building trust and confidence by all the disputants in a mediation process. Any party in a conflict needs to participate in mediation because of many reasons that are not solely dependent on the benefits of the mechanism as a dispute resolution strategy. For my company, it is important to participate fully in the conciliation because that is an act of compliance with court orders. Participation of the boss in the dispute resolution process shows commitment to the rule of law and finding a long-lasting solution to the dispute which is before the judicature. Since the participation of institutions in the peace talks process is ordered by a judge, the company's involvement is mandatory. In addition, the engagement of the organization in the conciliation process restores public trust in the corporation, which would otherwise dwindle if the commercial entity fails to engage in mediation. In brief, the involvement of the firm in the mediation process is an order by a court of law that needs to be implemented lest it is recharged with contempt of court. Again, participation in the mediation process is not a matter of going before the mediator and other disputants and refusing to speak. Full participation of the company boss entails following all the procedures that characterize the mediation process. It means that whether the company is represented by the attorney-advocate or not, it has to relay its submissions during the disputant's opening statements session. Therefore, by discussion and talking, the company responds directly to the mediator and the aggrieved party's statements in an attempt to define issues that have been raised. Without a doubt, neither the company boss nor the attorney representing the company can go to a mediation process and refuse to speak, as the mediation process requires their input in terms of speeches. Dialogue is important for a vital process of mediation, but it has its risks as well. More specifically, misguided dialogue can be disadvantageous to the party that is involved in it. All the conversations of parties in a dialogue, by and large, should be within the guidelines of the set rules that govern the mediation process. The risks that dialogue poses to mediation are that some information may be relayed that in turn would undermine the process of conflict resolution. For example, if in the process of dialogue, the aggrieved party realizes that the harm meted out to them was a result of a premeditated action by the other party, the mediation may breed hostility. Furthermore, dialogue can be disruptive to mediation sessions because as parties tend to be immersed in it, they may lose focus on the real intention of the mediation process. It is on this account that disputants are advised to exercise a lot of restraint when speaking during mediation. Information that is always shared by the parties involved in a mediation process is treated with a lot of confidentiality. In this regard, not all the information shared during mediation can be used in a court of law. Nevertheless, the nature of the information to be shared in a mediation process is guided by the ground rules that have been laid by the mediator. Besides, mediation is a strategy for conflict resolution and not a fact-finding mission. Therefore, the former employee cannot use the information or the data from mediation to prove his case before the court at the trial if mediation fails.